A pre-marriage will. What happens to the surviving spouse? Do they take what's in the will, or do they get some other share? Hi, I'm Darren Findling of the Probate Pro, and you can imagine certain circumstances where this type of fact pattern would occur. Some of the examples in videos that I do, the circumstances seem to be so far off from reality, but in this particular case, it happens quite often. Maybe somebody creates a will many years earlier in an earlier marriage, then never does another estate plan and marries. What happens to the surviving spouse? What about this scenario? Somebody creates a will with their fiance shortly before the marriage and then dies, or actually marries and then dies. What's the effect of that will? Well, there's a specific statute that is created in Michigan called the Premarital Will Statute, and it's MCL 700.2301. And it protects the surviving spouse in certain circumstances. It provides that the surviving spouse gets their share as if the person had died intestate. That means without a will. So they're entitled to not less the value of the share of the estate that the surviving spouse would have received if the person that executed the will had died without an estate plan. So it protects them to ensure that they're going to get their intestate share, except under certain circumstances. And these circumstances seem to be pretty intuitive and obvious. One, from the will or other evidence, it appears that the will was made in contemplation of the marriage. So imagine a scenario, maybe it's a second marriage, and a will is being executed a day or two before the marriage, and they decide how their estate is going to be distributed after somebody dies, and then they get married. That type of will control, meaning the spouse has to live by that will, not by the right to get their intestate share. Another circumstance would be if the testator expresses within the will that they're specifically addressing that if they get married down the road, that spouse is bound by the will. So they're contemplating or expressing a circumstance in which they're going to get married, and they express it directly in the will. And the third is that if there are specific transfers made outside of the will, that you can show are a substitute for a testamentary provision. So imagine somebody names somebody in a life insurance policy or transfers assets instead of including it in the will. The statute says that if it can be reasonably inferred from the amount of transfer or from other evidence, that would be an exception to this larger rule that protects the surviving spouse. Now, under all of these circumstances, a spouse who receives an intestate share under the provisions that we're referring to still has a right to an election under the will. And there is a statute that defines and controls how the right to elect against the will occurs. So there is a premarital statute where the spouse may be omitted or their share reduced, and then there's a right to elect against the will. And you have to read both of these statutes together to define the rights that the spouse would get and the share of the estate that the spouse would be entitled to. It gets complicated. And we have situations in which fact patterns in which this occurs, and you are deciding which statute is more favorable to the surviving spouse. These types of issues require skilled, competent legal advice, and we strongly urge you to work with a competent probate practitioner if you face these types of issues. At the Probate Pro, we're passionate about everything probate. If you've got more questions about probate-related issues, visit us at theprobatepro.com or call us at 833-PROBATE.